LegalStix Law School. In today's insightful webinar on contract drafting and negotiation training, we are privileged to have a leading figure in the legal landscape with us today, that is Mr. Bhumesh Verma itself. Sir boasts nearly 30 years of unparalleled experience in the field of including merger and acquisitions, joint ventures, private equity, and many more. An adept advisor on technology transfers, corporate structuring, and regulatory approvals. He has also been an integral part of Global Business Lawyers League, collaborating with law firms globally. In addition to his vast professional engagements, Sir has enlightened professionals and students alike with his practical training skills, particularly in contract drafting and corporate laws. Sir, welcome, and we are very privileged to have you in here.
Thank you very much.
Yes, sir. Over to you, sir.
Great. Well, I feel happy and privileged to be addressing you people. Very good afternoon to all of you. Contracts surround us throughout our personal lives as well as professional life. Whatever business you are doing, whatever legal practice verticals you are pursuing, and even if you are a management professional, you cannot do without contracts. Isn't it correct? Our life is full of contracts day in and day out. By contracts, we mean agreements which are legally enforceable. Being law students, I hope most of us would be law students. So we would know what sort of contracts we are talking about, what sort of agreements we are talking about. So why are contracts oral or written, executed or agreed upon? The objective behind two or more parties getting into a legally enforceable agreement is either to do some business together or to give something to someone or to receive something. It could be products, services, or it could be exchange of some promises to do something or not to do something. But you would have observed we face so many challenges in enforcing our rights in so many contracts. Or sometimes we may feel that we or our clients have been bombarded with so many obligations. We don't want to be in such like situation. So how do we overcome that? How do we secure our client's interest to the maximum? In the sense, how do we enhance our clients' rights, benefits, entitlements, powers in a contract? How do we reduce the risk, exposure, obligations, liabilities of our client in a contract? Now, enhancing rights and benefits, reducing obligations and liabilities, this requires very fine balancing. That is an art. So what would be a good contract from every party's perspective? A good contract would be the one which is easily understandable, which is easily implementable by whichever people going through this contract who are supposed to implement this contract, be it management professionals, be it doctors, be it architects, be it engineers, be it anyone. We have to bear in mind as to which people will be working on these contracts. So a good contract would be one which is easily understandable, which is easily implementable, and which is easily enforceable. Whatever we may deem fit in our scheme of things to negotiate and execute. Sometimes things do not go that way. There is divergence in parties' attitudes, expectations, performance levels, commitment levels, and so on and so forth. So sometimes things do not go the way they were expected to. So how do we enforce this contract? That becomes the key question. So the considerations for a good contract are that it has to be easily understandable, easily implementable, easily enforceable. How do we manage that? By drafting our contract well in advance, by negotiating well with the other party. This is how we can secure our client's interest to an optimal level. So what are some key considerations? Today, let us discuss those distinct features of a contract we should concentrate upon. And those who are interested in this subject definitely can go for repeat sessions or more sessions or longer sessions and so on, or workshops and so on. But let us begin the discussion today on the subject. Now, what is the tradition about contract drafting? The tradition about contract drafting is to draft very long, very comprehensive, sometimes non-understandable sort of contracts in terms of an L to L communication, a lawyer to lawyer communication. Too much of legal language, heavy language, complicated language, which non-lawyers find it difficult to understand. That is one aspect. Second aspect is the verboise, the wordiness, using more words than necessary. Using more words than necessary, what are the drawbacks? The reader loses interest, reader gets bored, reader does not concentrate on what you are trying to say, reader does not get to the point that you are trying to make in your contract. So the result is indifference or too many counter proposals or objections. If the other party does not understand what you're trying to say, that is the most likely outcome. And the drawback of using too complicated, too legal, too verboise, too jargon sort of words, again, is the same. So what do we have to do? Now, you have to understand what is the job of a lawyer. Do we have more of law students here or legal professionals? If there are any professionals, I'll be very happy to hear from one of you. What do you think is the job of a lawyer? You may unmute yourself and please speak up very fast. What do you think is the job of a lawyer? Yes, Prasenji. What is the job of a lawyer?
Hello, am I audible to you?
Yes, please.
Yeah. So a lawyer's job is to assess the client's needs first and to
Right.
make things easier for him.
Right.
Complex things in easier things. That's what
Yes.
the draftsmen also do, legal draftsmen.
Right. Yes. Very good. Anyone wants to add to what Prasenjit just said? What do
Sir,
lawyers do generally?
empathetic process.
Yes, Satya. What are you saying?
It is empathetic thought process of lawyer will makes to understand the issue while drafting the contract or whatever it may be.
Right.
Empathetic.
Okay. Yes. Anyone else? Amit, you were trying to say something?
Yes, sir. We should look to mitigate risks while at the same time try to facilitate business.
Yes, very good. Dheeraj also says to resolve the complicated legal problems. I think the crux of everything that you are saying, Saikat, you wanted to add something?
To protect the client's interest.
Yes, client's interest is paramount for any lawyer, right? So whatever considerations we are discussing here, the client's interest is paramount, primary importance. Ultimate beneficiary has to be the client. So our job is to represent the client in a very effective way and get the maximum benefit possible for our client, or reduce the risk or exposure of our client as much as we can. Now, how do we achieve that? We can achieve all this for our clients by way of words, written words or spoken words. So this is why good drafting skills is most important armor for any lawyer. Any lawyer, any practice vertical cannot do with lousy drafting skills. Whatever practice vertical you may be in, drafting is non-negotiable for you. So good drafting helps us in replicating the client's thought process, the client's expectations, client's rights, benefits, entitlements, to enforce it with maximum force. We can do it through good drafting. So our drafting skills have to be good, and we have to fall in love with words. We have to be knowing when to use which word, how, to what extent, because in legal drafting, every punctuation mark, every word, every sentence, every provision makes a difference. We have hundreds and thousands of examples on this. Every word is different in law when it comes to drafting. A client may come to you, and most likely client will come to you when for contract drafting. It will tell you, I'm entering into this commercial transaction. The other party is giving me this, and I am giving this. So the crux is I'm giving this and I'm getting this. That's it. Giving, give. In your contract, will you write give? My client is giving this. No, we have to choose the word very carefully. What word are we going to incorporate in the contract? Give. What does this give mean? Is it a sale? Is it a transfer? Is it a loan? Is it a return? Is it a payment? Is it a compensation? Is it a guarantee? Is it a contribution? Is it a security? Is it a reimbursement? Is it a commitment? Is it a gift? Is it a supply? What is it? Every word will have a different legal meaning. Every word will have a different legal relationship. Every word will have different legal implications. Every word will convey different rights and obligations. Every word will attract different laws. So we have to be very particular with every word that we are using in our contracts. That is the, you can say, burden of drafting, and that is the beauty of drafting. We have to weigh almost each word carefully as to what are we incorporating, what are the likely consequences, what is the legal relationship that we are creating by using these words. Now, unfortunately, Many of the lawyers, like some other professions like news anchors, political leaders, and so on, even some lawyers also are infested. Some of us suffer from what is called verbal diarrhea. It can be verbal, it can be in writing also. We do not know where to stop. We incorporate so many things which are unnecessary, not required, only padding up, but they may complicate the things for our client. They may reduce the benefits, entitlements of our clients, and they may in fact enhance the liabilities and exposures for our client, which is counterproductive. The more, have you observed, the more you talk about anything, particularly superfluous, the more problem you will get into. Everyone is on social media these days, right? WhatsApp and Twitter and here and there. The more you are talking, the more you get into trouble. Same applies to drafting also. So our emphasis has to be on using as less words as possible. Less words, but effective words. Less words, but effective words. Our focus has to be on making the contract effective, legal, enforceable, valid. So instead of the number of words, number of provisions, number of pages to our contract, we have to emphasize on effectiveness of what we are incorporating, because the more words we use, the more unnecessary words we use, we confuse the purpose. We may go contradicting from one place to another, slowing down the reader, confusing the reader, and the reader losing interest in the subject matter. Excess of anything is very bad. Another interesting thing you may keep in mind while drafting contracts or any other legal drafting is, imagine yourself as a storyteller. Imagine that you are not drafting a contract, but creating a fiction. This will go to the other party or its lawyers. Your story, your version has to be interesting, worth selling. The other party has to buy your version. Other party has to agree to your version as much as possible. Other party should object to your story as less as possible. The more your story gets sold out, the more convincing your story is, there will be less objections, there will be less counter proposals, there will be less time in negotiations, and there are more chances of the contract getting executed, the transaction concluding. The more objectionable your contract is, the less likelihood of it ever getting executed and the parties getting to commence their contractual relationship. So not only, less words, effective words, and so on, also imagine yourself as a storyteller. Write a good story in your contract or legal pleadings, because even what happens in courtroom also, same facts, like an accident happens. So the accident site is the same, the accused is the same, the victim is the same, the engaged vehicles are the same, timing is the same for both the parties. What do the respective lawyers of both parties do? They try to sell their version of the story to the court, that on these facts, these provisions should apply. And which party wins? Parth, in a court proceeding, which party wins? Anyone would like to reply? Which party is likely to win the case?
Sir, who persuade the judge most?
So whose version of the story is better. Story is the same. Both lawyers are trying to sell their version of the story to the judge. So your story has to be convincing, whether in courtroom or whether in boardroom in terms of a contract. So your drafting should be so good, so convincing that the other party has least grounds to object to your proposals. And lousy contracts not drafted carefully are the biggest contributors to corporate litigation. What is corporate litigation about? Enforcement of contractual provisions, invariably. So if you draft your contracts well today, it reduces the possibility of going to enforcement. You having to enforce. A good contract is the one which you don't have to enforce, which you have to implement and reap the benefits of your commercial understanding with the party. That is a good contract. The best contract is one which you keep in your drawer and never have to look into. And the relationship goes on autopilot mode. That is a good contract. Anyway, so what would be some good tips for better legal drafting? First tip would be the KISS principle. KISS, KISS principle. Those who have been following me on social media, some of you would be aware of this principle, KISS. Anyone? What is this KISS principle?
Sir, keep it simple and smaller.
Yeah.
Yes. Anyone else?
Keep it simple and short.
Yes, very good. Is my screen visible?
Yes.
We'll discuss 5 principles for good drafting. First one is KISS principle. So keep it short and sweet. Keep it short and simple. Keep it sweet and simple. Whatever you can remember easily, you remember that. The idea is to write less and to write simple. Writing less does not mean we leave what is important. Capture everything that is important, but do not waste your words. That is the idea. So make it so simple that no one can misunderstand, or do not keep it ambiguous, open to multiple interpretations. Because why do people go to court? People go to court when there are 2 interpretations possible of an enactment or of a contract and so on. And there is mismatch between the parties' expectations from that contract, that provision. Then only parties go to court. So keep it so simple that no one can misinterpret it. Second principle is, okay, you can watch this also. In name of simplification, you should know whether you are actually simplifying or not. Please see this video. So, do you people agree with this simplification approach? Is this how should we simplify?
No, sir.
Not really.
Was there another option?
Yes, sir.
What
Yes,
was
sir.
the other option?
You could have break it into 2 parts.
Break into
Right.
two parts, or sir, to pour the tea in another cup.
Right. So sometimes what happens, you would have observed, sometimes adding too much technology complicates things, right? Now, most of the banks, they have put all the banking on their phone, right? Or on mobile apps. So you call up the helpline and you don't get a response for 10 minutes, 15 minutes. Sometimes there are no people on the phone. There are hundreds of options on the phone. Press 1, press 2, press 3, press 9, and so on. But what if your problem is not listed under those options and you want to speak to someone? You have to wait for so long. And then they would say, you know, we work only from 8 a.m. to 8 p.m. So it's not simplification. Sometimes in the name of simplification, you complicate it. So be judicious. Simplification or less words would not mean leaving something important out of the purview. Okay, be judicious, be very careful. So first one was simplicity. Second one is misery with words, less words. First is simplification, simple language. Second is misery with words. Use as less words as possible. No unnecessary words. Every word in your sentence should deserve its place. Not a word less, not a word more. Should be the mantra for you. Less words, but effective words. Third principle would be condensation. If there are any science students here, can you briefly explain what is condensation? Anyone still remembers condensation principle? Here we can, take the example of this condensed milk. What is it? Concentrated milk, right? Used in making sweets and so on. While drafting a contract or negotiating a contract, we have to hear to so many people, different people. We have to listen to our own client. We have to listen to the other party. We have to listen to the other party's lawyers. Sometimes certain regulatory bodies may get involved. Sometimes we may have to discuss it with the government as well, government authorities, before concluding a contract, seek their approvals and so on. Sometimes you may have to speak to bankers, creditors, and so on. So you have to hear all this. But as we said earlier, we cannot incorporate everything in a small contract. We have to optimize the contract for the maximum benefit of our client as much as possible. So what do we have to do? We have to listen to everything. We have to consider everything, but we have to encapsulate it. We have to reduce it in writing. So we write less. We try to take the best part from everything that we have heard. In Hindi, we would call it suno sabki or suno sabki or karo
अपनी
man ki. That is wrong approach in contract drafting. Suno sabki or karo apne client ke interest ki. So you hear everyone, but you reduce it to what works to the maximum benefit of our client within legally permissible parameters. It is not that, something works to the best interest of our clients, we incorporate it, but that is illegal or unenforceable. That we cannot afford to do. After all, a contract is a legally enforceable agreement. We have to bear the legality in mind all the time. Right? So this is the condensation part. Next part is understandability. Doctor's prescription. Does everyone understand? Most of us cannot make out anything from doctor's prescription. Or marriage mantras as well. At least Hindu marriages which I have attended, the mantras are chanted in Sanskrit language. Very, very few people, less than 1% people, actually get to understand what the Panditji is reciting. What are these mantras about? So, our legal drafting, contracts and otherwise, should not be like this. People, becoming parties to a contract should be able to understand it very well in advance as to what are they getting into, what are their respective rights and obligations. It should not be that they trust you blindly, you and the other lawyers, and they, in a hurry to conclude a contract, sign something, and later on repent or blame you that you had not explained these things to us properly while drafting this contract. You should not fall into that trap. Try to make it understandable as possible for common people. Keep the audience of your writing, this drafting, in mind. Does anyone know about what happened to Adipurush, the movie? Anyone's got any idea?
It was failed movie. It's not.
Yeah, so what happened to that movie?
Sir, matter go to litigation.
So what was the problem with that movie vis-a-vis the... Yeah, so what was the problem with the movie?
Because the narration.
Why was it not received well? Why was it not received well?
The narration is not to the established belief what they have.
Sir, people were not able to connect with it.
Right.
Sir, they
Yes.
try to copy, however, it's not copied successfully.
Right. So language, as Vijay correctly pointed out, was the problem, and Dheeraj also. Language was the problem. Language could not resonate with the people. Right. So similarly, we have to keep our audience of this contract in mind. Is our client legally qualified, well educated, able to understand whatever we are writing? We have to draft accordingly. We have to bear in mind this status of, say, readability of all the stakeholders. Can all the parties actually read this easily, understand their respective rights and obligations? That should be a good test for a contract. Can the parties actually read and understand this contract and implement this? And if need be, go for enforcement or not? If they cannot, go back and simplify your contract, make it more understandable. Okay, so understandability is the fourth issue. Fifth issue is value addition. Today, we have so many tools available. You ask one question and you get a million answers. There is one Babaji on internet, isn't it? Who provides you million solutions for every single question, every single query that you put up. He's been there or for a number of years, Google Baba, right? There is so much information available on Google, and now there's another element added to it. What is that?
AI, sir.
AI, yes. Yes, ChatGPT, Merlin, this, that, there are hundreds of such instruments. Now, do you think only you, 40 of you who are there in this conference, only you have access to that, these tools? Everyone has got access to these. So a client may on its own go to Google, go to ChatGPT, download a contract, change the names of the parties and the dates, and be done with it. Why should the client engage you for drafting? The client will engage you for drafting only when the client believes that you are legally qualified, you know the subject matter better than the client, you can protect the interest of the client, you can reduce the liabilities and exposure of the clients, you can enhance the benefits, entitlements, rights of the client. Only then the client will engage you. So if the client is coming to you, say with 5 pain points, that these are 5 biggest issues that I can think of that need to be taken care of in this contract, you have to be able to provide the client more than what the client expected. This is the reality of today. If you only work on these dotted lines and you download something from internet, make cosmetic changes, names, dates, particulars, then there is no value addition on your part. That is not good drafting. This is not what the client is expecting. The client could do it itself. So a good certain amount of value addition has to be there. Client has to be more comfortable, more confident, more satisfied, more empowered after having come to you. Client should get a feeling that his interests have been safeguarded by you. You have given the client more than the client could have done by himself. Then only your drafting is good. So these are the 5 traits of good drafting which you should bear in mind. Value addition, in the reverse, if you want to see, value addition, understandability, condensation, simplicity, and misery with words. Any questions so far on what we have discussed? Anything that you cannot understand or resonate with so far what we have discussed? Okay, now let's come to the components of a contract. Value addition, Dheeraj, is what are you bringing to the table? What are you bringing to the table? What is it that you have incorporated in the contract that the client did not know or the client was not aware of? Which are boilerplates we'll discuss later. What are the essential components, more or less, of every contract? Several provisions will be peculiar to every contract, different way, but some components you will find virtually in every contract. So every contract that you get to draft or review or negotiate, please tick these boxes, whether all of these have been captured or not. If not, then you go back to the contract, complete it, and then only move any further. First important component of every contract is a good title, correct title. The title of any contract should reflect what is the relationship of the parties or what is the transaction being carried out under this contract. Is it a joint venture agreement? Is it a lease agreement, or leave and license agreement? Is it an agency agreement? Or is it a sale deed? What is it? What is the transaction or what is the relationship of the parties? Is it a partnership agreement? People are agreeing to become partner through this contract. So it has to be relationship driven or transaction driven. Title should reflect it. Next, most important part is what is the subject matter? What is being carried out through this contract? What is the transaction? A is providing services, B will pay money. That is the subject matter of a service agreement. Or A will give his property on lease, and Miss B is taking this property on lease and will pay money for this lease. That is the subject matter of a contract. Third essential element is, are there any preconditions for the parties to become entitled to exercise their rights? Like, you may have an appointment letter issued by a company. Do you become employee of that company from issuance of that appointment letter?
No, sir.
When do you become entitled?
Sir, when we start working for the company.
Yes. The date on which you join your duty. There could be some preconditions. You have to submit the NOC from previous employer. You may have to submit maybe some medical certificate. Yes. Non-speakers, please mute yourself. Unmute only when you are to speak something, please. Thank you. Like, you may have a lease agreement, but there is earlier tenant which is living in the same property. So there would be preconditions from both sides. Landlord will insist on you, if you are the tenant, to make advance payment of rent, pay security deposit, submit police verification certificate, and so on. And your preconditions would be, you get the property vacated, you get the property painted afresh, you get the property furnished as per my specifications, then only I will enter the property. Okay, so the day the property is ready for my occupation, I start occupying it, the rent starts from that date. So many contracts have these preconditions attached to them. Then after preconditions are the rights and obligations. When this transaction is carried out, or when this contractual relationship comes into being, what are the respective rights and obligations of the parties? One party's rights are the other party's obligations. Like, we have fundamental rights under the Constitution, right? Everyone would have studied. Do we have fundamental rights under the Constitution of India?
Yes, sir.
So these rights are the state's obligations. State has to ensure that we can exercise these rights. So rights and obligations are not independent. If I have the right to receive certain services from a telecom company, I have an obligation to pay for it, isn't it? If a telecom company insists on a payment, advance payment of monthly rent, it is okay, that is right. But in lieu of that, it has an obligation to provide me services. So no right, no obligation is exclusive. There is an underlying right or obligation, as the case may be. With right, there is an obligation. Then we have to provide for a working framework. Like, you people must have been in college. What is the working framework? We have a 5-year course or 3-year course. We have semester system. We have exams. We have midterms. We have moots. We have a promotion policy to next semester or next year, and so on, right? That is the working framework. And we have a time frame also, that this is a 3-year course. If you have not passed certain subjects, you complete it within 4 years or 5 years. Otherwise, you will be kicked out of the college. Or in CA, this is, you have 4 groups. You complete it within 7 years. Otherwise, there's nothing. Or we have this lease agreement for 1 year, 2 year, 3 years, and so on. So or we have this employment agreement. What is the time frame? You will be paid on a monthly basis, or you will be assessed for promotion on a yearly basis, or for increment on an yearly basis, or for bonus will be evaluated for you on a yearly basis. So there can be no contract without any time frame. Like you get an appointment letter, you get a very good package of so many lakhs or so many years, crores, but you want a time frame for your payment or not. So in every contract, there has to be time frame for fulfilling rights and obligations of the parties. Thereafter, we come to the representations and warranties part. Parties give assurances, make statements to each other under contract to comfort the other party, to convince the other party that yes, I'm capable of performing my services, my obligations under this contract. And if something goes wrong, this is how I will compensate you. Like you go to any big showroom to buy any product. So the entire sales team will make you representations, make you statements about the product that you are thinking of buying. That these are the performance standards. These are the specifications. Like for a phone, this is the screen size, this is the camera, this is the processor, this is the RAM, and so on, right? So these are representations to convince you that this product or service is good and you should buy it. That is representation, and warranty follows representations that yes, we are making these statements to you. If this product does not conform to what we are stating, these are your remedies, these are your fallback options. Like you get a replacement, you get a refund, or you can return it, or replacement, refund, or say repair. What are your fallback options? So reps and warranties form a formidable part of any contract. And then we come to the remedies. As we were saying earlier, there are bound to be some differences. There are bound to be some deviations in the standards of performance expected by the parties. So if something goes wrong, how can we repair the situation? How can we retrieve the situation? How can we salvage the shortfall in expectations? So what are the rights available to the non-breaching party in case a breach happens, in case a violation happens? That should form of a part of a good, effective contract. If the remedies cannot be breached, the parties cannot come back to the same level as they were before, there is bound to be a dispute. If in estimation of one party, the other party is not performing properly, there has to be some dispute resolution mechanism. How do parties resolve their disputes? If there is some disagreement, there is some mismatch, there is divergence, there's a delay, and so on. How do parties resolve their differences in an amicable manner, if possible? We have to provide different levels of escalation. If the parties can sit across, discuss it, and hammer it out between themselves, nothing better than that. Things remain private and can be resolved amicably, happily, ever after. Fine. If not, then there could be recourse to arbitration, mediation, conciliation, and so on. If even that does not work, litigation is the last recourse available. Now, in devising a good dispute resolution mechanism in a contract, we have to emphasize on the efficiency, expediency, and economical nature of the mechanism that we are proposing. It should not be disproportionate in terms of costs. It should not be too time consuming, and it should actually be effective, providing relief to the parties as much as possible. So instead of going to litigation, ADR is being resorted to in most of the cases in contracts these days. So that is if the parties can resolve their disputes. If they cannot resolve and they want to exit out of this contractual relationship, they don't want to live with each other for whatever reasons, with cause or without cause, and so on, there has to be a termination mechanism in the contract also. A good contract should provide flexibility to the parties to disengage at an appropriate stage. One should not be bound by this sort of, if the marriage has gone bad, one should not be stuck in a bad marriage forever. You should provide for a termination mechanism in a contract. Yes, any questions? I saw something in the chat. I think there was some question in the chat. Remedies for breach, Rahul, you were asking. So if a party does not fulfill its part of the bargain in the contract, there is some deficiency in service or performance or payment or anything, what is the recourse available to the non-violating party? What action can it take? Can it seek penalty? Can it reduce consideration for the other party? Can it go to court? Can it terminate the contract? What are the remedies available to the non-defaulting party? That is the idea for this. Any other questions? No, the time for our yes, Khushali. Specific performance damages, compensation, indemnity, liquidated damages. There are so many remedies available. So the time for our discussion today was very brief, and this was just to give you an initial idea about how to go about drafting and negotiating contracts. We are initiating a 30 hours online workshop on this because I'm undertaking this course with several national law schools and private universities, going into 32 hours on this subject. And many students and professionals who do not get this opportunity as they at their law school have been requesting for an online course. So we have collaborated with LegalStix to provide this online training to those who are interested in the subject. Those of you who are keen to pursue this subject and be proficient in contract drafting, reviewing, and negotiations are welcome to join the course that is starting on August 21 in an online mode. I think 3 hours a day for 2 weeks or 10 days. Any questions?
So, am I audible?
Yes.
You earlier said that while making a contract, we have to take the we have to take consideration of the other party. We have to keep them in mind also. But then,
Yes.
if I own a company, wouldn't I be taking into consideration more of my interest rather than the other party's interest?
Yes, that's good. But if you keep it one-sided, the other party will not accept all your proposals. So a good effective contract is the one which balances the rights of all parties. If every party's rights obligations are taken into consideration and you come up with a reasonable draft, it will take less time in getting to the execution stage. That is the benefit of a balanced draft. If you put it everything one-sided, the other party will either not accept it at all or will put in too many objections or counter proposals. That will elongate the negotiation period.
Okay, sir. Thank you.
That is the drawback. So you can like make it 60-40, 60 to your benefit, 40 to the other party, and eventually it will settle at 50, 55 or something. Yes, any other questions? This is my latest book on the subject, Practical Guide to Drafting Commercial Contracts. Besides, we are starting this course on next Monday. So those who are interested in this subject, and it's a very interesting subject and it's a very wide, vast subject. When people ask me, sir, how long will it take me to become an expert in contract drafting? I feel like laughing. I say, I'm learning it for more than 30 years. So you should also spend some reasonable time in it. We are constantly learning, all of us. So it will take you some time, yes, but it's fun and it is worth it. The time you spend, because it is not a mechanical process. Contract drafting is not a mechanical process. It is an experiential learning. The more you learn, the more you practice, the better you get at contract drafting. That is what I had to submit in today's discussion. Look forward to keep interacting with you on social media and elsewhere. We also have a lot of daily tips as well as articles on the subject on LinkedIn and various other online platforms. You are welcome to follow me and us on social media. We also have a Telegram group for daily tips on contract drafting. Those who are interested can find out on LinkedIn.
Sir, my question is, sir, class will be on Saturday, Sunday, or continuously
Daily.
throughout?
Daily, 2 weeks, 10 days. So we'll take break on Saturday and Sunday.
Thank you so much, sir. This was a very insightful webinar. I hope students might have liked it and loved it, to be honest. If you have any queries, questions, you can ask. All right then. Thank you so much, sir.
Thank you very much. Look forward to keep in touch. Thank you. Take care, everyone. Best of luck. Bye.
Thank you so much, sir. Yes, anybody having any query?
Thanks, sir.
No, as such.
All right. All right. Thank you so much.
Thank you.
Thank you, everyone.